Hi, everyone. Welcome, and thank you for joining us. Thank you very much, World Animal Justice and Sabine for organizing this webinar series and for inviting me to present on this topic. Today, we turn our attention to overlooked victims of armed conflict, animals. Animals have been used in warfare throughout history, from horses, pigeons, and elephants to modern uses like bomb-sniffing dogs, mine-detecting rats, and even in military experiments. So the objective of our presentation is to explore the existing legal protections of animals during wartime and examine the sanctions, or lack thereof, for the violations of those laws. While international humanitarian law indirectly protects animals, it fails to acknowledge them as direct victims of war crimes. And this is a result of the anthropocentric focus of IHL, which is disconnected from the contemporary value placed on animals. But as we all know and feel, animals are more than just collateral damages. And warfare impacts all animals, from domesticated ones left behind during mass displacement to captive zoo animals and wildlife whose habitats are destroyed and lives taken, including at sea. The suffering of animals in urban warfare, including liminal animals, and the increased threat of wildlife trafficking further exacerbate the challenges that they face. Today, to give you an idea of the number of conflicts going on, there are 120 active armed conflicts globally in over 60 states, which is triple the number since 2000. And the legal framework for non-international armed conflict is the less developed, which means less protection for animals and poses challenges for animal protection. However, customary IHL, International Humanitarian Law, has evolved to provide some protection, but practical enforcement remains difficult. Why? Because it is primarily designed to protect human beings and does not address animals. But as we will see, it contains provisions that can. The inconsistency in their enforcement leads to war crimes going unsanctioned due to the exclusion of animals under international criminal law, which creates a gap in accountability for serious harm inflicted upon them during armed conflict and grave breaches of international humanitarian law when no direct connection to human suffering is established. And this gap we want to fill it, to put an end to it. And in our discussion today, we aim to challenge the status quo and re-examine the treatment of animals in armed conflicts, recognizing, as Peters reminds us, that aside from a few multilateral treaties protecting endangered species, the welfare of animals has always been poorly regulated at the international level. So our goal is to provide an overview of the current legal frameworks, identify areas for improvement, and outline a clear path forward, enhancing the protection of animals in armed conflict, while also recognizing the practical and contextual constraints of both IHL and ICL, and considering their humanitarian rationales. We propose expanding their scope to explicitly protect animals as sentient beings affected by war without compromising their effectiveness. So we will start by examining the legal protections for animals under international humanitarian law. We will analyze the sanctions and enforcement for animals under international criminal law and highlight this accountability gap due to the absence of recognition of animals as direct victims of war crimes, which remain largely unpunished and do not on their own trigger international criminal action. And finally, we'll explore proposed reform to enhance legal protection for animals in armed conflict and improve accountability for violations and war crimes, while remaining pragmatic to avoid the risk of an empty promise and undermining the effectiveness and legitimacy of these rules because of the special context in which they operate. So, international humanitarian law, also known as the law of armed conflict or the law of war, consists of rules which in wartime protect persons who are not or no longer participating in hostilities and restrict the methods and means of warfare. It aims to limit the effects of armed conflict for humanitarian reasons and to mitigate human suffering during armed conflict. International criminal law is a body of law that addresses the most serious crimes of concern to the international community as a whole, such as genocide, war crimes, crimes against humanity, and crime of aggression. It aims to prosecute individuals responsible for those crimes and promote accountability and justice at an international level. And war crimes that interest us today are serious violations of the laws and customs applicable in armed conflict, specifically, giving rise to individual criminal responsibility under international law. This includes grave breaches of the Geneva Conventions, such as willful killing, torture, or inhumane treatment of protected persons, and other serious violations of the laws and customs of war recognized as customary international law. They contain two elements: a contextual element, which is that the conduct must take place in the context of and be associated with an international or non-international armed conflict, and a mental element, the intent and knowledge, both with regards to the individual act and the contextual element, the armed conflict. So this is a picture of Patron, which is very famous in Ukraine and has even received an award for his work as detecting mines. Let's begin by examining the current legal protections under IHL and their criminalization under ICL. So in theory, animals cannot be targeted by belligerents, except when they qualify as military objectives, such as when they are used in combat, carry weapons, or guard military objectives, or when the harm that they suffer constitutes proportionate incidental damage resulting from attacks on military objectives. In other words, animals used for military tasks do not enjoy any protection nor combatant status, nor can they be considered prisoners of wars if they are seized by the enemy, which is a status that applies to human persons when they are conducting warfare. However, in modern warfare, the use and killing of animals is hardly a military necessity. We do not need to use animals in warfare. If they are not used in warfare, or animals can be considered civilian objects. And attacks on civilian objects, thus including animals, are prohibited unless there are military objectives. And the proportionality principle mandates that harm to civilian objects must not be excessive in relation to the anticipated military advantage. The principle of distinction, proportionality, and necessity require that such harm must be minimized. And the balancing exercise is contingent upon animals' uses, values, benefits, or relationship with humans, and we can think that it can also depend on the recognition of animals as sentient beings. Intentionally directing attacks against civilian objects constitutes a war crime. This provision indirectly protects animals as they are and can be considered civilian property. And this also constitutes a war crime under the soon-to-be established African Court of Justice and Human Rights. The same applies to attacks causing incidental damage to civilian objects, including animals, which would be clearly excessive in relation to the anticipated military advantage. And this picture is a ship that was struck by a missile launched by Yemen's Houthi, put in the Gulf of Aden in January, and which was transporting thousands of animals, and which can clearly be considered as a war crime, but will hardly be prosecuted as such because attacks against property hardly trigger international criminal action, even less when it is against animals. Animals used for medical purposes, such as search and rescue dogs or horses used for medical transport, may be protected as equipment belonging to medical units or medical transports because of the medical functions they are assigned, but not medical personnel because they are not persons. They could benefit from reinforced safeguards adapted to medical care needs, preventing direct and indiscriminate attacks on them, and attacks causing excessive harm are prohibited. Intentionally directing attacks against medical units and transportation using the distinctive emblems of the Geneva Conventions constitutes a war crime in both international armed conflict and non-international armed conflict. And acts against medical transportation in non-international armed conflict could be prosecuted under charges such as pillage and destruction or seizure of property not imperatively demanded by the necessities of the conflicts. The special regime applicable to cultural property prohibits attacks and damage must be avoided to protected property, such as buildings dedicated to religion, art, science, education, or charitable purposes, and historic monuments. And it can indirectly protect animals in these buildings or in the vicinities, or even animals used for religious purposes. And endangered species may be protected in the framework of the preservation of cultural heritage of great importance for all peoples of the world that need universal protection. Under the Hague Convention on the Protection of Cultural Property in the event of armed conflict. The obligation to take special care to avoid damage to cultural property is set forth in many military manuals. The destruction of such property, which can host animals or even big animals, is prohibited under international criminal law, and if such acts are intentionally directed against protected cultural property, they can be prosecuted as war crimes. Al-Mahdi's case, even though it did not address a case involving, the ICC did not address a case involving animals. It's notable because it's one of the first instances where an individual was prosecuted solely for the destruction of cultural heritage, and it underscores the increasing international recognition of the importance of preserving cultural history, and also this demonstrates the seriousness of crimes against cultural property. So this can also be a way forward to indirectly protect animals, because this was a war crime on its own, not connected to human suffering. Animals indispensable for the survival of the civilian population, such as livestock, also benefit from some very indirect protection unless they are used by opposing forces or directly support military action. Very indirect because this provision aims to prevent human starvation. And of course, it does not protect the animals per se who will be eaten in the end. Like one way or the other, they will be slaughtered. Depends how and by whom and for which end. But it is prohibited to intentionally starve civilians by depriving them of objects indispensable to their survival, and this indirectly protects farm animals, for example, used for human sustenance. Concerning environmental protection, which can really be a very promising way forward, all animals are components of the natural environment and benefit from protections prohibiting the use of means and methods of warfare that are intended or may be expected to cause long-term, widespread, and severe damage to the environment. For instance, scorched earth policies have disrupted effects on wildlife, as does the destruction of the Kakhovka Dam illustrated, and naval warfare on Black Sea dolphins in Ukraine. These apply in both international armed conflict and non-international armed conflict, as these rules are part of international humanitarian law. The only such explicit provision in the ICC statutes, Article 8(2)(b)(4), criminalizes launching attacks, knowing that they will cause widespread, long-term, and severe damage to the natural environment, and this indirectly protects animals as part of the environment. The International Law Commission and the ICRC have opined that the term natural environment should and does encompass fauna, thus indirectly protecting animals during armed conflict through environmental protections. No special provision covers aquatic animals, but they are part, of course, of the natural environment and wildlife. And it is worth noting that the Office of the Prosecutor of the ICC recently announced a new policy initiative to advance accountability for environmental crimes under the Rome Statute. And this is a window of opportunity that needs to be seized to consider animals and to include them within the need to close the accountability gap for environmental crimes, because animals are part of the environment, and all animals, not just wildlife. Finally, pillaging, extensive destruction, and appropriation of property not justified by military necessity are prohibited. Pillage also applies to natural resources and cultural property. Natural resources can be wild animals. These provisions apply to the theft and destruction of animals. In the Bemba case, for example, the ICC noted the pillaging of livestock as part of the charges, and the deprivation was not justified by military necessity. In Ntaganda, the ICC addressed the destruction and pillaging of property, which included livestock as well. This is definitely a military tactic to pillage animals, to steal livestock, whether to starve the population or not. This doesn't have to be to starve the population. Because as you can see in the Ntaganda case, in the Lubanga case, pardon, the ICC noted the forcible handover of cows by civilians to armed groups when addressing child soldiers' forced enlistments, consisting of a cow or a child, when families had to either give a child to be enlisted to fight or give a cow to the armed groups. In Ntaganda, the court interestingly noted that even if inherently grave and having the potential to cause severe consequences for the victims being, of course, humans, crimes against property are generally of lesser gravity than crimes against the life and or bodily integrity of persons being, again, humans. This demonstrates that crimes against property, and property in this case being animals, are far from being a priority before the ICC and in international criminal justice in general. And the focus is primarily on crimes against the life and bodily integrity of person. So we can wonder whether the best strategy is to pursue advocacy before the ICC or to pursue another path that would be focused on crimes against animals, because there might always be second-class victims or not victims at all within this specific system. But we can also reflect on the evolution of environmental crimes that show a gradual evolution and think that the same might be possible for animals and work towards this solution. So there is a lot of work and reflection about it and a lot to study. But let's reflect on the legal shortcomings that these legal frameworks demonstrate. So the lack of explicit provisions addressing direct harm to animals results in significant gaps in accountability for cruelty against animals during conflicts, that is for sure. And the pursuit of crimes committed against animals in war per se is not a high priority for international criminal justice, that is also for sure. And this is clearly in connection to the anthropocentric focus of international criminal justice, but of our legal systems more generally. The anthropocentric nature of IHL and ICL exclude animals as direct victims. I think that is something that everyone will remember after our webinar series. None of these provisions is tailored to animal welfare or to the protection of animals' interests. We are like trying to draw from indirect protections, but none of them are adequate to protect the specific needs of animals. We are, of course, speaking of emergency, non-normal times, and we are not speaking about covering all needs. We are not talking of rights. We are talking of emergency times and protecting from the worst atrocities and sanctioning the most serious crimes. Still, this should be adapted to their special needs in these emergency times, and they should at least be able to count on at least one provision tailored to their welfare and their need to be protected from the most egregious forms of cruelty during armed conflict. And the legal characterization of crimes affecting animals reflects their status as property rather than sentient beings deserving of protection. And so this anthropocentric focus limits protections for animals, treating them primarily as property or for their utility to humans, as is shown by the protection of farmed animals against starvation for human beings. ICL provisions primarily protect animals in their capacity as property or in relation to human harm, but never on their own. If we look at the under protection and including animals within the environmental crime of environmental damage, this crime itself suffers from vagueness in the definition and high thresholds to trigger the crime. Non-international armed conflicts are excluded from its scope, which reduces its applicability and leads to changes in enforcement and prosecution. And of course, if they are not clearly defined, it also changes the enforcement and prosecution. The terms widespread, long-term, and severe are not clearly defined, which leads to ambiguity and potential inconsistency in enforcement. And this also hinders the principle of legality, which requires the crimes to be precisely defined. And the subjective nature of the mens rea, which is knowledge and intent, makes it challenges to establish that the perpetrator knew that the attack would cause disproportionate environmental damage. So all of this is detrimental to the enforcement of this crime, of this provision. And the exclusion, of course, of corporate liability and the focus on natural person terminates restricting the prosecution of environmental harm while expanding the liability to moral persons would open new opportunities for prosecution and help protect the environment and animals more broadly. Still, there is some hope and some solutions have been put forward, although we must be careful in the choice of their implementation. And given the dynamic nature of conflicts and evolving societal values, updating IHL and ICL rules to better protect animals and the environment is timely. How timely and how long it might take is a matter of appreciation and mostly political will. But this could involve, of course, developing clearer definitions for environmental damage and including animal harm in IHL and ICL to ensure precise and consistent application, and lowering the thresholds for proving environmental and animal-related war crimes to enhance accountability, and advocating to lower these thresholds and extend environmental damage war crime, including animals, to non-international armed conflict because they are prevalent. Milburn and Van Kozen also have proposed integrating animals into the just war theory through the principles of proportionality and necessity. because they argue that considering animals will not make the theory impractically demanding, but will instead ensure its human aspects, and it promotes a more comprehensive ethical approach to warfare, considering the welfare of all sentient beings affected by military actions. However, there are practical difficulties in data collection, and it is complex to weigh human and animal interests that could hinder implementation. The dynamic interpretation of existing ICL provisions to better protect animals is my favorite way forward. Considering contemporary ethical standards, the principle of humanity, and the evolving recognition of animal welfare. Peters, for example, argues that the principle of humanity in IHL and ICL can offer broader animal protection, defined as covering crimes that violate feelings and shock the conscience of humankind as a whole, because there are certain things that humans must not do, because the types of crimes are intuitively recognized as inherently and plainly wrong by all members of the human community. And as a result, if humans were to tolerate such behavior, interhuman morality would be negatively affected. It's probably the best strategy given the lack of political will, and that a new treaty on animal welfare is not the top agenda priority for states. And Peters and Dermtin argue for animalization of international humanitarian law. They argue for clarifying existing provisions, explicitly recognizing animals as specially protected objects within the existing IHL framework. For instance, the definition could explicitly mention animals as protected entities during conflicts. Systematic integration, using the Vienna Convention on the Law of Treaties to incorporate principles from international animal welfare and environmental law into IHL to enhance the protection of animals without needing a radical overhaul of existing laws, and emphasize the principle of humanity and the dictates of public conscience as outlined in the Martens Clause to include considerations of animal welfare and sentience. This is in alignment with the overarching humanitarian goals of IHL without disrupting its binary classification system, because without a surprise, it's also a binary classification: persons, objects, civilians, combatants, etc. And as they argue, harming animals runs counter to humans' obligations to themselves, and the idea is that, as Peters argued, that the principles of humanity offers further animal protection. In addition to their arguments, considering that 2/3 of countries have adopted anti-cruelty animal laws, and that a WTO panel affirmed in 2014 that animal welfare is a globally recognized issue in the steel products case, we can consider that incorporating international animal wealth, that drawing on principles from international welfare and international environmental law and incorporate this principle into IHL is not such a bizarre idea, and that this is in alignment with societal value and the evolution of international law, and that the time has come for the gradual development of international criminal animal law. And in addition to animalization of international humanitarian law, we can argue for the animalization of international criminal law. Finally, adopting a new treaty that explicitly protects animals during armed conflict, recognizing them as sentient beings and subjects of rights rather than merely objects of protection. And I'm seeing that as going from conscientism for humans and utilitarianism for animals to maybe tomorrow conscientism for all sentient beings. So many authors argue, some authors argue that to further animal welfare and our rights during warfare require a categorical change and a more utopian way to rectify IHL's shortcomings would be to develop a new instrument solely focusing on the protection of animals during armed conflict. Given that Lex Lata only grants some limited protection to certain beings, goods, or values. I don't think we will have time to go through all proposals, but they mainly argue to draft innovative legal instruments focusing on the protection of animals during armed conflicts. And for example, I propose drawing on the crime of animal ecocide proposed by Lego and Broman and extend it to include the protection of animals during armed conflict, or a new treaty or amendments could explicitly include animals as victims of war crimes, recognizing their sentient nature and intrinsic value. I'm less optimistic regarding this one because we know that it requires political will and it's very risky and complicated to amend this framework while the Geneva Conventions are ratified by all countries in the world. So we should be very careful and pragmatic when we want to amend this regime. But something that we can do and that is less risky and perhaps doable is to work towards, as a first step, the adoption of a specific protocol prohibiting the use of animals in the conduct of hostilities and conducting experiments on animals for military purposes. And such agreements can be adopted at the national or regional level, and they don't have to or wouldn't disrupt either IGL or ICL structure. By the way, this kind of discussion parallels the case of adding ecocide as a fifth core crime, in relation to which there is an active debate. And we need the consent of state parties to amend the Rome Statute to further state parties. And the absence of consensus could induce more fragmentation, and this is not useful at all to accountability and to effectivity of international law, and particularly to IHL and ICL. But we can advocate for the criminalization at the domestic level to oblige states to conform to their laws. And we can rely also on existing crimes within the Rome Statute, but to protect animals indirectly, and on the dynamic interpretation of the provisions, relying on international environmental law and emerging international animal rights law and comparative animal protection laws as well, that are very interesting, and national animal rights decisions to improve the protection of animals during armed conflicts, especially in light of the recent Office of the Prosecutor's announcement, which opens a window of opportunity. So yeah, this is my opinion, that it is unlikely that a treaty will be adopted soon to grant fundamental rights to animals, unfortunately, or that state practice will rapidly evolve in this sense, but it is possible to act in some respect regarding animal rights during armed conflict. conflicts. I will rapidly conclude with a roadmap. So in the short term, we should promote dynamic judicial interpretation of existing IHL and ICL provisions, to extend protections to animals and leverage the principle of humanity in the Martens Clause and draw on sources from IAL and global animal law and even international human rights law. That can be very surprising. And advocate for national legislative reforms to incorporate protections for animals during armed conflict to reflect evolving ethical standards. In the medium term, we can work with international organizations to adopt resolutions and declarations supporting the humane treatment of animals in armed conflict, and even think of a one health and one welfare approach to the protections of humans and animals in armed conflicts. This can lay the groundwork for future legal instruments. And in the long term, we can be optimistic and hopeful and advocate for the adoption of a new international treaty specifically focused on protecting animals during armed conflict. And this treaty, of course, should recognize animals as sentient beings and provide clear legal protections. And also strengthen mechanisms for universal jurisdiction to prosecute war crimes against animals, ensuring accountability and justice beyond national borders, and strengthen mechanisms for international criminal justice, whether at the ICC or through a new international court, because there's not just the ICC at the international level, and there will soon be also the African Court of Justice and Human Rights. In conclusion, I think you all understood that animals are not protected from cruelty in international law, and international humanitarian law and international criminal law are no exception, because international law and international humanitarian law and international criminal law mainly focus on human beings and overlook animal welfare, which is disconnected from consideration of animals. And while they provide some indirect protection for animals during armed conflict, significant gaps remain, mainly because of jurisdictional and substantive limitations, which prevent effective prosecution. Animals remain second-class indirect victims, if we can even say the word victims, in connection with human victims of war crimes. But as I explained, there are potential ways forward. Thank you very much for your attention. I'm happy to send you references if you want, and I will share my presentation on academia and ResearchGate, and this will include the list of references. Sorry, it's very, very difficult to speak today. This will include my list of references in the presentation that I used today. Thank you very much.